welcome to my lecture on patentability requirement. In the last class, we have seen we have dealt with the issue of novelty, and in this lecture I will be dealing with the doctrinal framework and the concept of non-obviousness. Now, we know from our last class, which is basically which we have seen that there are three different parameters which needs to be satisfied to get a patent protection, and almost this has become a global feature, and this has also become an integral part of the Indian patent system. Now, in the last class we have dealt with novelty, and in today's class I will be looking at the non-obviousness doctrine, and then I will be spending few words about the usefulness or the utility understanding. Now, the first thing, any legal analysis starts with the legal provision, and as you can see in your screen, you can see there are two definitions, and the first definition is the definition of inventive step, which is there in section 21JA of the Patent Act, our Patent Act, and you can see also the definition of obviousness or non-obviousness, which is being given in section 103 of the US patent law, which is US patent law, which is US Code 35 section 103. Now, whether these two are equal or not, we will come to that, but let us look into the definitional parameter which has been set by the national statute, the domestic legislation of India, actually section 21JA of the Patent Act. It says that, very carefully we have to note that inventive step means feature of an invention that involves technical advance as compared to the existing knowledge, or there are two things, either it should be actually it involves a technological advance as compared to the existing knowledge, or second thing, having an economic significance, or both, and that makes the invention not obvious to a person skilled in the art. So, the definition makes it crystal clear, either of these two factors, a technical advancement or economic significance must be there. If both of these elements are present, there is no problem, but which is actually which must be there is this, that it must be something which is non-obvious to a person skilled in the art. Now, come to the US understanding. The way we have used the term inventive step, US has used the term non-obviousness or obviousness. Now, the US statute, which is corresponding to section 21JA of the Indian statute, section 103, it says that a patent for a claimed invention may not be obtained notwithstanding that the claimed invention is not identically disclosed as set forth in section 102. So, that means even if it is not actually even if it is satisfying the criteria of novelty, still a patent can be denied if the difference between the claimed invention and the prior art are such that the claimed invention as a whole would have been obvious before the effective filing date of the claimed invention to a person having ordinary skill in the art to which the claimed invention pertains. Patentability shall not be negated by the manner in which the invention was made. So, we have seen almost what is inventive step in India. The same concept is actually an age old concept, is considered to be the age old concept of non-obviousness in USA, but there are certain subtle differences, and in this class we will not be looking into those differences. Why? Because from where from we get the clue that we will not be making any distinction so far as this class is concerned, because in my last class I have mentioned about Article 27 of the TRIPS agreement, and there is a footnote, and I have actually shown you in this slide the footnote itself. The footnote says that for the purpose of this article, the terms inventive step and capable of industrial application may be deemed by a member means here the WTO member, to be synonymous with the term non-obviousness and useful respectively. So, for this class we are using this term, the term inventiveness, interchangeably with the term non-obviousness. Now, what does this non-obviousness means? See, to be very precise, this is actually a more complex inquiry than the novelty inquiry, and then we have seen that even there are attempts to make objective criteria so far as non-obviousness is concerned, but it is very much subjective and it depends upon the person who is reading the prior arts. Now, we have seen in the last class that so far when it comes to novelty, all the claim limitations must be present in a single prior art, and there we have also learned that for the purpose of non-obviousness inquiry, it is very much possible to combine prior art references. Now, suppose there are two prior art, invention number 1 and invention number 2. Now, a person comes out with an invention. In fact, that invention embodies all the elements of claim invention 1 and invention 2. The question is this, that will it be an obvious invention or will it be a non-obvious invention? Now, here we have seen in the statute, as we have seen in the earlier slide, in the earlier class also, the statute says that person having ordinary skill in the art, and the short form of this is posita. So, Mr. Posita is the main focus of patent law, and we have to look into the prior art from the lens of Mr. Posita, who is actually having the ordinary skill in the art. That Mr. Posita is not actually an high level scientist, nor he is an ordinary mechanic. He is in between these two, and this Mr. Posita would be looking at invention number 1 and invention number 2, and if Mr. Posita thinks that Mr. X's invention to be something already known, then the invention is obvious. But if Mr. Posita thinks that the invention it cannot be ordinarily deduced by combining invention number 1 and invention number 2, then the invention is non-obvious and thus it is patentable. Let us take a simple example. This is actually a common article which we use in our daily practice. See, this is called this post-it note. So, we use a piece of paper and that can be pasted on any surface, that can be pasted as actually as a reference mark in a book which you have studied. It can also be pasted in a door where you can leave a note for somebody whom you could not see. Now, to be very precise, 3M was holding a patent in respect of post-it. Now, what are the two prior arts in this regard? The first prior art is actually we know about paper, and paper is known to us for centuries, for thousands of years. And then we also know about glue, because if we use an ordinary glue to paste a paper on a surface, it would be permanently, actually it would get permanently attached to that surface, and if we are trying to take that paper out, the paper would be destroyed. One would land up in tearing the paper. But if we can make a glue, and if that glue is actually a glue which is readherable, means we can put it back and take it back, put it back and take it back. If that happens, in that case actually it is the glue is something which is known, paper is something which is known, but this two prior art is not actually asking someone to make an invention where he can make a kind of glue which is non-permanent in nature. So, therefore, 3M got a patent, although the prior art was something where both were present. So, a posita, a person having ordinary skill in the art, Mr. Posita would never think about applying a glue in a paper for the purpose of making it actually a piece of note that can be pasted at any moment and that can be taken back at any moment. Now, as we have see, there is something else more than novelty is required for the purpose of non-obviousness understanding. And the idea behind this principle that a concept may be completely novel, but that may not be sufficient enough to form the prior art, as such does not provide sufficient leap forward to the technology. So, first of all, see the purpose which non-obviousness functions, what is the purpose which basically non-obviousness does? It protects the public domain in a more robust, in a more comprehensive manner than the novelty doctrine. And we have seen that novelty doctrine, in fact, it protects public domain. It ensures that something which is already in public domain, no unscrupulous individual take it back in his private domain in the form of patent. But here, since in non-obviousness inquiry, we can actually combine different prior art references, therefore, it protects the public, it protects the member of the public in a more vigorous, in a more aggressive manner than the novelty requirement. Now, in this regard, we will get back to the first case law, which is coming from the US. It is known as the case law is called the Hotchkiss versus Greenwood. What has happened in that case? We all aware of metal doorknob. This metal doorknob in this patent, which was the subject matter of the dispute in this case, this metal doorknob was replaced by a clay or a porcelain doorknob. And therefore, question is this, that yes, if someone is replacing a metal doorknob by a porcelain doorknob or clay doorknob, obviously it is novel. But anyone who is having the knowledge of a doorknob, he or she can actually use any other material. And in this case, the Supreme Court of United States held, it held that actually an invention to be patentable, it requires more skill and ingenuity than possessed by an ordinary mechanic acquainted with the business. The required degree of skill is that of an inventor, not of a mechanic. So, here the skill which is required to make an invention patentable, not merely because it is novel, it is patentable, it has to also qualify certain grade, the grade of not of a mechanic, but the grade of an inventor. So, that is what the crux of the issue that was discussed in Hotchkiss, and at a later stage it became when the 1952 Act was enacted in USA, it became an integral part of the US patent system, and we have seen section 103 of the US Patent Act. So, now we will try to understand that what are the guidelines that needs to be followed while determining the question of obviousness or non-obviousness of an invention. Now, in this regard, the reference point is the seminal case of Graham versus John Derry and Company, where the US Supreme Court, based on the 1952 Act, as we have seen that section 103 of the 1952 Act, it in fact made non-obviousness a part of the US patent statute, and the interpretation comes up in this 1966 case. The first thing which needs to be considered is the scope and content of the prior art. We now know that so far as non-obviousness is concerned, prior art references may be combined. However, what are the different prior arts that can be combined? See, if we are allowed to combine all pre-existing prior art, in that case perhaps it would be very difficult for a patent seeker to obtain a patent. So, then what are the prior arts that should be taken into consideration for the purpose of determining the obviousness or non-obviousness? That is the first thing which needs to be decided. Then the second understanding is this, that the differences between the prior art and the claims at issue are to be ascertained. So, the question is here that prior art combined in one hand and the claimed invention on the other hand, and now we will be comparing and contrasting these two things, and we will try to find out that what are the differences between this prior art and the claims which have been claimed by the patent seeker. And then the most important question would be at last, who is the posita for the purpose of looking at the prior art? The level of ordinary skill in the pertinent art is resolved, and once these three elements are properly construed and constituted, against this backdrop, against this understanding, the obviousness or non-obviousness of the subject matter has to be determined. And these principles are still the governing principles in the US. Now, what has happened? That in addition to that, there are secondary consideration, and what is the secondary consideration? We will come to that a little bit later. Now, such secondary considerations such as commercial success, long felt but undeserved need, failure of others, etc., must be utilized to give light to the circumstances surrounding the origin of the subject matter sought to be patented. As indica of obviousness or non-obviousness, these enquiries may have relevancy. So, that means, see, a Mr. Posita finds that the prior art is something which is defeating the patentability of the claimed invention. Still, whether that claimed invention is a commercial success, whether there was a market need for that, and it is basically addressing a long felt market need, all this may be still taken into consideration, even if the Mr. Posita finds that it is something which is obvious. So, we will try to elaborate with the help of examples in a later part of this lecture. Now, so with this regard, now we have seen the analysis of this test, and this I have analyzed when we were trying to understand this test. Now, the latest case law in this regard, which is again coming from the US, this is with regard to certain paddle assembly, whether those paddle assemblies are obvious or not, and then US Supreme Court again relying on these parameters which have been laid down in Graham versus John Derry and Company, and this is the operative portion of the judgment. We will look into the operative portion. What it says, that in determining whether the subject matter of a patent claim is obvious, neither the particular motivation nor the avowed purpose of the patentee controls. So, what matter is the objective breach of the claim. If the claim extends to what is obvious, it is invalid under section 103. One of the ways in which a patent subject matter can be proved obvious is by nothing there by noting that there existed at that time of invention a known problem for which there was an obvious solution encompassed by the patent's claim. So, now the question is this, that here what matters is the objective breach of section 103 of the US Patent Act. Now, what is the objective breach? We will try to understand, but before that we need to understand two concepts. One is called the teaching suggestion motivation. So, this teaching suggestion motivation is basically a kind of guideline that how to combine prior art and how to use those prior art for the purpose of determining the question of obviousness or non-obviousness. And to be very precise, if after performing this kind of analysis, if the prior art is teaching away, if the prior art is teaching away, in that case there is the invention which has been claimed would be obvious. However, if the prior art combined together, if it is teaching in, see, that means teaching in and teaching away are the two important factor in determining obviousness, the question of obviousness or non-obviousness. Now, let us look into a Federal Circuit decision, Circuit Court of decision which has come in 2017. Here there was a patent of listing, suppose someone is searching internet and then the results are being listed. Now, there is a rollover area for viewing the displays, and which display this rollover area actually it displays descriptive text corresponding to a search result. Now, what has happened? The US Patent Trial and Appeal Board, that is the board instituted review of 4 claims of this patent. When Google, they objected to this the issuance of this patent. The board found, the Patent Trial and Appeal Board found that the claims are unpatentable because there are 2 prior art. First of all, one of the prior art they disclosed the rollover viewing area, and whereas the second actually the second reference also the first reference was about search result, the second reference was about rollover area, but all these limitations were not present in a single prior art references, but they were present in 2 different prior art references. So, when it comes to this understanding, the Federal Circuit Court of Appeal says that they have quoted the prior precedents, and then they said that a combination of known element is likely to be obvious when it yields a predictable result, that is actually quoting Teleflex, then obviousness may be defeated if the prior art indicates that the invention would not have worked for its intended purpose or otherwise teaches away from the invention. So, if the prior art is teaching away from the invention, it is obvious. And what is teaching away? The meaning of teaching away? A reference teaches away when a person of, again Mr. Posita, reading the reference would be discouraged from following the path set out in the reference, or would be led in a direction divergent from the path that was taken. So, a reference that merely expresses a general preference for an alternative invention, but does not criticize, discredit or otherwise discourage investigation into the claimed invention does not teach away. Does not teach away, this is the principle. Now, with this understanding, we will look into what is the scope in India. The scope in India is actually it has been laid down by the Supreme Court in the case of Vishwanath Pratap Radhesham versus Hindustan Metal Industries. So, what was the it was actually a kind of method of making utensils, and the utensils, in order to polish an utensil, one need to basically shallow dishes. What we have to done is scrap and polish them on some sort of headstock. And how to fix that utensil on a headstock? It is normally fixed either by a thermoplastic cement or held in the jaws of the chunk of the headstick. Now, this is a risky thing, because while polishing, while trying to basically polish it, while trying to polish it, it may create a kind of it may fly away, and it may hurt the person who is doing, and it can create accidents. In order to basically overcome this problem, the problem of actually the utensils flying away and hitting somebody else, the inventor herein, he has invented a device and method for manufacture of utensils which are safe, and then a patent was granted. And the question is this, that whether the method which was invented by the patentee, was it a novel, was it non-obvious? Now, with regard to this, the Supreme Court of India also follows the same approach, and I will read out the relevant operative part of the Supreme Court judgment. It says that it is important to bear in mind that in order to be patentable, an improvement of something known before or a combination of different matters already known should be something than mere workshop improvement, and must independently satisfy the test of invention or inventive state. US court uses this term skill skill more than that of a mechanic. The Indian Supreme Court uses this term that it should be more than a mere workshop improvement. And then the court says that to be patentable, the improvement or the combination must produce a new result or a new article or a better or cheaper article than before. So, this better and cheaper article than before, this is something which is the secondary market consideration in USA, like long felt need. It is addressing a long felt market need, something like that can also work in India. But to be very precise, when we looked into the definition, we have seen that the operating section makes it very clear that either economic consideration or sufficiently forward to the existing technology, and it must appear non-obvious to a person having ordinary skill in the art, that is the understanding. Now, therefore, there exists a doubt that where a particular invention is making only economic contribution, addressing a long felt need, will it clear the test of non-obviousness in India or not? Now, we are talking about secondary consideration for a long time, and I will conclude my lecture what is secondary consideration, and in order to make you understand this, I will take a simple example. And as you can see here, these are all what you call weights which are being used in barbell, and barbell is used for weightlifting. Now, what you see at the top, these are the prior arts which were existing, and you have seen that actually they are these weight plates. There are what you call there are weight plates which does have elongated opening. Some weight plates have one opening, some has two opening, some have four opening, and then what you see at the bottom is the patented weight plate. In patented weight plate, there were three elongated opening, and this would allow someone to grip the barbell and put it grip the weight plate and put it in the barbell rod. Now, after when the prosecution was going on, this is the claim 1, I will not read it out, it is, you can read it out from the screen, but when this prosecution for this patent was going on, and the applicant himself has cited a what you call a patent which was having two grip and a patent having one elongated grip, and these are the patent numbers. And even the examiner has cited a kind of patent, US patent having 4 grip. So, this appeared to be obvious, but the ultimately what has happened, the patent was granted to the applicant on the basis of long felt need. Now, the question comes up before the US court, again the matter goes before the Federal Circuit Court of Appeal in USA. The question is this, actually here there is a range of elongated opening, and where there is a range of elongated opening is disclosed in a prior art and the claimed invention falls within that range, there is a presumption of obviousness. However, this presumption of obviousness can be rebutted as per the evidence law if 2 things are proved, that the prior art taught away from the claimed invention we have learned, and that there are new and unexpected result relative to the prior art. Even what has happened, the iron grip, the court said that iron grip could not show any of these 2. Then there is another way to get away with this inquiry to show a commercial success or satisfaction of a long felt need. Again, iron grip failed to show this by adducing what evidence before the court, and as a result of that the Federal Circuit held that the claims are invalid. And few words about utility. Now, section 2(1) AC, and this slide you can see that I have compared and contrasted the European Patent Convention article 57 with that of section 2(1) AC. Both of these sections deal with industrial application. So, what is industrial application? So, to be very precise, you see that it must be capable of being made or used in the industry. Somehow I can come out with an invention in my laboratory. However, when actually I know fully well that when someone wants to make that invention or embody that invention in a product in large scale, he would not be able to do it. There would be this would defeat the utility requirement of patent. However, whenever an application is filed, unless it is disproved, there is a presumption of utility even in India. Thank you very much.